Hello to everyone, and thanks for joining our discussion today. The purpose of this conversation is to explore some questions around DEA registration for state licensed operators and some implications that should be considered. My name is Calvin Shannon. I'm a tax partner with BGM Advisory. A significant portion of my practice is within the cannabis industry. I'm grateful to have Hannah King participate in this webinar with us today. Hannah has been a terrific resource for several of my clients as they try to navigate these issues. Hannah, would you please introduce yourself?
Yeah, of course, Calvin. Thank you so much. And everyone, it's a pleasure to be able to present on this issue for you. My name is Hannah King. I'm a partner with Dentons. If you're not familiar with Dentons, Dentons is a global law firm. It's a full service law firm, but we have both a global and a national cannabis practice. I'm a member of our cannabis practice group. I've been practicing cannabis law since 2014, 2015, so over a decade now. I represent over 500 clients across the country. Almost all my clients are touch the plant. And we at Dens have done a lot of work around the rescheduling order, understanding it, communicating with the federal government around it, and advising clients on it. And I'm happy to share some of that information with you today.
Excellent. Thanks for that. And again, thanks for sharing your time today. Before we get started, I did want to mention that to the extent any listeners do have questions, please feel free to offer them in the Q&A section. We'll address questions as time allows. So with that, let's get started with the discussion. So there seems to be a lot of questions with regards to whether registering with the DEA is mandatory or not. Hannah, I'd like to get your thoughts about this.
Yeah, so I'll start by saying that it is our position and our opinion at Dentons that the DEA registration is mandatory for all state licensed medical cannabis businesses, and I'll explain why. And just because I have an obligation to advise you that it is mandatory, there are still business considerations. And we'll talk about those later for you as a business when you're deciding whether or not you want to file. But it is our understanding that it's mandatory. And here's why. If you look at the final order, I'm just going to talk a little bit about the final order. So on April 23rd of 2026, the Department of Justice issued a final order rescheduling a classification of cannabis, which they call medical cannabis, from a Schedule 1 to a Schedule 3 drug, effective immediately. And medical cannabis is defined both as FDA-approved drugs containing naturally derived cannabis and cannabis products produced by state licensed medical cannabis businesses. And it's really helpful, I think, for folks to understand the two ways under the Controlled Substances Act that the federal government can reschedule cannabis, because this informs kind of our understanding of why DEA registration is mandatory. So one way that the federal government can reschedule cannabis is the ordinary way, the way that people are most familiar with. And it's the process that cannabis has been going through since Biden's executive order in 2022, petitioning the government to look at the scheduling of cannabis. And so that process is there's a petition for rescheduling. The CSA requires the Department of Health and Human Services to do a review of all relevant scientific and medical data and make a recommendation. Then there's a mandatory notice and comment period that is sometimes followed by an administrative law judge hearing. So in the context of cannabis, there's an administrative law judge hearing. And then there is either a final order rescheduling that's adopted or it's not, and it stays on the same schedule. So that's the normal process. The other way the federal government can reschedule a substance under the Controlled Substances Act is that the Attorney General can unilaterally, without going through any of that process, reschedule a substance when it is their position, when they determine that it is necessary, that it is required in order for the United States government to maintain its obligations under certain international treaties. And so here, in the order that was issued on April 23rd, what Acting Attorney General Todd Blanche said was, "It is my opinion that in order to continue to comply with the Narcotics Convention of 1961, which the US became a party to, I believe, in 1967, that I need to reschedule medical cannabis from a 1 to a 3. But in addition to that, he said, not only do I need to reschedule it, we need to change the way that it's regulated going forward. And if you look at, I tell people where in the order this is, the order is long, it's relatively complicated. It goes back and forth between FDA approved products and state licensed cannabis businesses, so it can be hard to follow. But if you look at the order around page 20, 21, 22, he talks about how, you know, they've done a review of state programs. They think that the state programs have come a long way since California legalized medical cannabis, and that for the most part, state programs have put in place robust regulatory regimes that protect public interest, that make sure that patients have access to safe product, that prevent against diversion. Those are the two things that they're primarily concerned with. And that they don't want to disrupt patient access. They do not want to disrupt kind of existing medical cannabis infrastructure, but that they do think that the federal government, in particular the DEA, needs to be able to have some say over this. And so what they talk about in the final order is that going forward, it's going to be a model of dual federalism. And so states will continue to issue licenses to medical cannabis businesses. Those medical cannabis businesses, for the most part, will continue to operate under the laws in the state which they operate. They're not going to be subject to a lot of the federal rules and regulations that apply generally to DEA registrants. The state regulators are going to continue to oversee and enforce the state laws that apply to those medical cannabis businesses, but that those businesses will also be required to apply for a DEA registration. And that will allow the administrator of the DEA to, when they determine that it is in the public interest, so again, if there's a diversion risk or if there's a public health and safety risk, that they can deny a DEA registration or can revoke a DEA registration. And then they go on in the order to say, in order to facilitate that, the transition from the existing model, which is state licensed, state legal, but federally illegal programs, to state licensed operators that are also registered with the DEA, we're going to create a streamlined process for state licensed operators to apply for DEA registrations. And if folks file within 60 days, then the order says that they will be able to continue to operate under just their state license while their application is being processed, and that the DEA is going to implement an expedited process for review and approval, and that it's aspirational in some ways, but the goal is to review and process all applications filed within that 60-day window within a 6-month period. And in our experience, with DEA registrations for cannabis for research purposes, which were available prior to April 23rd. You couldn't be a state licensed operator to get those, but you could get those registrations. It was a much longer process. So that is 6-month turnaround would be fast. And so based on that language, that because to comply with the treaty obligation, which is essentially the basis of the authority to reschedule, they need to implement this dual federalism model. And also the language that talks about if you apply within the 60-day window, you can continue to operate under just your state license. Both of those things support our conclusion, in addition to just kind of communications with the federal government and other work we're doing in this space, that the intent is that this is mandatory, that the idea is that every state licensed operator is going to continue to operate with their state license, but they're also going to have a DEA registration.
Thanks. It's a very thorough answer. Towards the beginning of that, you had mentioned that this is your guys' opinion, but license holders need to consider this is a business decision and should consider let's say the pros and cons to registering or not. Maybe could you speak to that a little bit and some things that license holders should consider and maybe broken out in a couple different ways. Maybe it may be different considerations for a medical license, entity that owns a medical license only versus an entity that owns an adult use license only versus an entity that owns a license that's dual use. Does that make sense?
Yeah, of course. So I think I'll start with the benefits. You know, again, the order was very clear that the idea is that you know, the federal government is going to continue to rely on the laws of each individual state to govern these businesses. So each state licensed medical cannabis business is really going to continue to operate the way that they've been operating before, except you'll have a DEA registration, which makes you federally legal. And there may be more benefits than kind of this list that I'm about to give you, but what that could open up for you as a business operator is access to federal trademark protections, access to bankruptcy protections, the ability to transact with credit cards, access to capital that was foreclosed to you before. There are likely going to be uplisting opportunities, access to financial institutions, potentially interstate commerce, opportunities to export to companies that have legalized cannabis. And then in some ways, the ability to sleep at night, right? We've been operating for many, many years in this space where we've just been kind of relying on the federal government's position of non-enforcement. And while I think folks have gotten really comfortable with that, the reality is that could have changed at any moment. It was a policy decision that could have changed on a dime. And so there is that benefit to federal legality as well. So the downsides, I think the downsides in some way, or the things that people need to be considering, is that there are quite a few unknowns. I mean, one of the things that we expect to happen is that once you have a DEA registration and once kind of the program, once the 60-day window is closed and folks have applied for DEA registrations and those have been issued, that you're only going to be able to buy and sell to other folks who have DEA registrations. And part of this, I don't think the federal government recognized this as a con. The idea was all these state license operators are just going to apply and get DEA registrations, and then they can only transfer to each other anyway, and so it's not going to be a big deal. It's more complicated than that, right? Even if you're standalone medical, there are folks who are making the decision not to file for DEA registrations. And that likely means that if there are kind of vendors in their universe that do have a DEA registration, those folks will no longer be able to work with them. One of the things we are advising our clients to do is if you do have critical vendors, businesses that are really important to your ongoing operations, having conversations with those businesses about, are you intending to file? If you don't file and we file, it may impact our ability to operate, to be able to continue to work with you. So again, we don't know that the DEA is going to require that because it's not a requirement under state law. But if you look at the applications, there's supplier lists you have to provide the DEA registration number. It is a requirement generally that DEA registrants can only transfer to each other. So that's something to think about. Does that restriction impact your business? For co-located facilities or dual licensed facilities, Maryland, Ohio, Illinois, there's kind of a long list. Adult use businesses cannot, at least at this time, apply for and get a DEA registration. They are limited to companies who have a license from the state to cultivate, manufacture, or sell medical cannabis. And there is a question as to kind of what the DEA is going to do with dual or co-located licenses. Because from the DEA's perspective, what you'll have, within a single building is an operation that is a DEA registered operation. They are federally producing and selling a Schedule III drug, just like a DEA registered pharmaceutical company. But under the same roof, the same company, they will also be trafficking in a Schedule I drug, adult use cannabis. Any cannabis that falls outside that definition of medical marijuana is still Schedule I at this point. And so there are concerns about diversion. And so there are questions about, what are they going to do with co-located? They clearly understood that there were a lot of companies that were operating both adult use and medical. They reference it in the final order. They give notice that the Treasury Department is actually going to issue guidance helping people who are co-located, dual located in both markets figure out how to do their accounting because they'll have a Schedule III drug, not 280 doesn't apply, Schedule I drug, 280 at least for now applies. according to the IRS. Uh, and so that's something that we're still trying to figure out. So for folks who are dual licensed or co-located, we are advising to wait. We don't think that there is a legal benefit to filing earlier rather than later, as long as you file within that 60-day window. And the hope is that we'll have some additional information. I mean, I know Dentons has filed at this point hundreds and hundreds of applications because we did have clients that wanted to get it done. And some of those are dual license co-located, and we're hoping we'll get some additional information as they start to process those licenses to help inform that decision for folks. But that is something that folks need to be thinking about, that you may have additional risk if you're co-located. And then again, if you're adult use, this isn't something that's available for you. If you're just standalone, purely adult use at this time, you should not be submitting an application for a DEA registration, because you'll have to check boxes that will be, you'll be providing false information on the applications.
Well, thanks for that. I guess maybe a couple of follow-up questions and comments. First of all, you briefly mentioned 280, and I'm sure a lot of our listeners are curious about 280, and I promise you later on in this discussion we'll address 280 and 280 relief specifically. I guess, Hannah, it would seem to me, based on this, it would be advisable for license holders that are considering or applying for deregistration or not to consult legal counsel to speak to their specific situation. Would you agree with that?
Yeah, absolutely. I mean, I think that it is really important to make, again, these are business decisions, to make an educated, thoughtful, fact-specific decision, regardless of what that is. And it is really helpful to have legal counsel help advise on that.
So some issues maybe with to the extent that a license holder is going to do this DEA application. Issues around sensitivity with employee information, which needs to be shared, and some concerns that the license holders may have.
Yeah, so if anyone on this call, so interestingly, even though there is this 60-day window to file, at this point, the DEA has only made available the registration specific to medical cannabis dispensaries. So in some ways, they're building the plane as they're flying it. And when they initially started saying we're going to open up the application period, there was a bulk manufacturing application, which is what folks prior to this had used to apply for cultivation and manufacturing for research purposes. It's not a clean fit. It's particularly not a clean fit for dispensaries. And so they rolled out a new application for dispensary registrants. They have indicated, and I am going to get to the answer. This is just important context. They have indicated that they are going to be rolling out applications for manufacturing, cultivation, and distribution as well, but those are not yet available. If anyone here has gone on and kind of flipped through the medical marijuana dispensary registration, it asks you to provide the names, the date of birth, the social security number of anyone who's going to have access to the controlled substance. So that includes all of your employees. If you have HR staff that's offsite that don't have a keypad key to be able to get into the building, they may not be included, but these are some of the kind of specific questions that it's worth talking through with legal counsel. But we are getting a lot of questions from folks about, can we provide that sensitive information? And the answer is yes, you can provide that information if you have a reasonable business purpose to do so. You also have to provide, and as long as you keep it confidential and you don't use it for any other purpose. You also have to provide attestations that regarding kind of employees, whether or not employees have state or federal convictions, both misdemeanor and felony related to controlled substances. There's another attestation about disciplinary actions, state, federal, tribal disciplinary actions. So there's questions about how you might be interpreting that are worth asking legal counsel, because I think there's a number of ways to interpret that. You can interpret it more narrowly so that it's related just to controlled substances. So if you're an employee who has a badge from a state and that badge has been suspended or revoked for malfeasance, for violations, then you would say that there'd been a disciplinary action. If somebody had been a massage therapist and had a licensing violation there, maybe you wouldn't report it because it's unrelated to just to controlled substances. But those are questions that it would be helpful to talk to a lawyer about. It's really interesting because I was talking to one of my colleagues the other day, because I think when you pull up the application, it's pretty short. We hear people be like, "Oh, it's totally easy. Like we just kind of filled it out. Took a couple of minutes." Whereas we at Dentons have like 15 to 20 lawyers who have been full-time cannabis lawyers for a long time. We have decades and decades of experience, and we're spending a lot of time thinking through what are they asking for here? What's the scope of the response? What's the potential reaction or consequence if you respond this way versus that way? So we do encourage people to be thoughtful in completing these applications. But that's kind of one of the things. The other thing that folks are raising, and I'm sure, Calvin, you've probably heard this as well, is the application asks if your firm has a DEA registration already, and if the firm has in the past experience in handling a controlled substance. So for all state licensed cannabis businesses, you're going to say no to the first one. You don't have a DEA registration because it hasn't been issued yet. And prior to April 23rd, state licensed cannabis businesses were not allowed to apply. You were trafficking in a controlled substance. You weren't eligible. But you're also going to check, yes, you have experience handling a controlled substance. I think people get really nervous about that. With the exception of a small number, maybe some of the license holders in Texas that just got their licenses but haven't been operational, or a small number of other folks who fall under that category, everyone completing these applications is going to say yes. There is an opportunity to explain what you mean when you check yes to experience handling controlled substances. And there again is a place where it's really important to be thoughtful. You can explain to them, okay, yes, I don't have a DEA registration, but we have experience, which is a good thing. Usually that's important when they're issuing these licenses in kind of the non-cannabis context. But how do we have that experience? We've been operating in compliance to a robustly regulated state medical program with licenses, something along those lines. There's another section that we get a lot of questions about. So it asks, and this has to do with folks who are co-located or dual located. But will your firm be handling or dispensing recreational marijuana? So again, you're essentially telling the DEA, yeah, we're asking you to give us this DEA registration, but our plan is to continue to also traffic in a Schedule I drug. And so you have to be honest on these. There are significant consequences to providing false information. There are various ways to interpret them. So again, this is a place where an attorney would be helpful. What does firm mean? If you've got a parent company with separate subsidiaries, one does medical, one does adult use, does that change your answer here? It's possible, but it's worth seeking legal counsel around that. But again, it's very clear from the order and from the guidance that came out from Treasury saying we're going to provide guidance around folks who are operating medical and adult use, that they know that there are folks who do both. There could be something out there that we don't know, but we're not seeing any indication that there's going to be a kind of a change or an effort to shut down the adult use market, or to change the position of non-enforcement. And so that is a question as you're considering whether or not to file these applications. That is information that you're going to have to provide, and you're going to have to provide it honestly.
All right. Yeah, definitely a lot to think about. And, as I mentioned, Amanda mentioned several times, to make sure you understand how you're answering these questions and responding to these questions that you apparently are compelled to respond to, and do so in a thoughtful manner to the extent you need to get counsel to do so. Well, maybe with that, we'll jump to 280 and ask a couple questions about that. So, Hannah, what do you think? Does a license holder need to be registered with the DEA to enjoy 280 relief?
So we think the answer is yes, that the rescheduling of medical cannabis is per the final order, which again, it is the reschedule. So 280E only applies to companies and individuals who are trafficking in a controlled substance in the meaning of Schedule 1 or Schedule 2. So if you are trafficking a controlled substance that is a Schedule 3, Schedule 4, Schedule 5, 280E doesn't apply to you. So under the order, the way we read the order, because we read the order as requiring DEA registration in order to fall within that definition of medical marijuana, that you would have a state medical marijuana license and a DEA registration, we are advising folks that that it is possible / likely that in order to be eligible for 280E relief, you would need to have that DEA registration when you go to file your taxes in 2026. We think it is. So the other thing I didn't talk about, and I'll talk about this now, Kelvin, because I think it makes sense, is that the same day that this order issued, the final order issued, the Treasury Department issued guidance that said, more guidance coming around how to do your accounting if you're adult use and medical, but that for purposes of 280E, they were treating rescheduling as retroactive to the tax year in which the order was issued. So if you're on a calendar tax year, 280E would stop applying to your medical business on January 1st, 2026. We don't think we're going to get that additional guidance from Treasury. I mean, it's possible, but we expect that Treasury might wait to watch the kind of rescheduling for adult use cannabis or cannabis more broadly play out before it issues guidance, additional guidance. And so I don't know that we'll get outside this 60-day window. I don't know that we'll get more guidance from Treasury or elsewhere that says definitively, yes, you need a DEA registration in order for 280E to stop applying. So that the safe conservative approach would be to apply for the DEA registration, and that will ensure that 280E stops applying to your business, starting January 1, 2026.
Makes sense. And you did speak about the adult use rescheduling, and that is something we'll come back and talk to and speak to in a little bit. But continuing with 280E, what are your thoughts about when potential 280E relief will be effective? And, you mentioned in the press release from the Treasury that they had given. It seems to me that they had indicated they thought 1/1/2026, but do you have any additional thoughts or comments about that?
Yeah, so it's interesting, right? Because I mean, Calvin, you know this, 280E is a unique code provision in that it's a standalone. There's no regulations. It's all it says is that individuals or businesses who are trafficking in a controlled substance within the meaning of Schedule 1 or Schedule 2 can't deduct ordinary business expenses or take tax credits. There's nothing about when it applies or when it doesn't apply. And so there is language, we get asked a lot about this. There's language in the final order where the Department of Justice, who isn't the one who has jurisdiction over determining when 280E applies and stops applying, that really is the Treasury Department. But Department of Justice puts in its final order that it recommends that Treasury consider making the effective date of rescheduling for purposes of 280E back to the date in which each taxpayer got its medical license. Treasury did not do that. So the guidance that came out of Treasury, again, makes it retroactive to the beginning of this year. They could change. It is possible that Treasury could come out with additional guidance. It is possible that folks who have taken a statutory non-280E position could potentially leverage that language. I think for folks who have taken a statutory non-280E position, it is a timing position, right? So it is saying the question for it is saying a few things. So it's saying that the IRS the Treasury Department is the one who has jurisdiction to determine kind of when 280E stops applying, when something stops falling within the meaning of Schedule 1 or Schedule 2. And that it's a timing, that it is not, as IRS is saying, once a final rule is adopted, that's not what the language says. And we do think it's interesting that the Treasury Department has given retroactive application for 280E. We don't know what the basis is. There's nothing in the language that supports that. But it is helpful to the statutory argument that's saying, yeah, you're going to adopt a final rule rescheduling, but really cannabis stopped falling within the meaning further back. It's a timing issue. It's retroactive. The effect of rescheduling is for 280 is retroactive to 2019, 2020. And so we do think that one, that the fact that Treasury kind of made the effective date retroactive, even though they just picked the beginning of the year, helps support an argument that that it is not forward-looking from the date of rescheduling. And then also, there just is that language could help bolster folks who end up in a position where they're kind of engaging with IRS around their tax opinions.
Well, the you spoke to people taking the statutory position that 280 doesn't apply before, but apparently the IRS, at least at this time, is indicated January 1st, 2026. But there are folks taking position that it's sometime in the past. The relief goes back sometime in the past. How important would it be for a license holder taking that position to get a reasonable basis tax opinion to support taking that position?
So there are significant risks, including heightened penalties, civil fraud. If you take a non-280E, if you're a medical operator that takes a non-280E position prior to January 1, 2026, without a tax opinion or disclosure. And so we are strongly advising that if folks want to take a non-280E position for any year, to either file amended returns or file it their original returns in 2025, that they get a tax position and that they disclose the position on the filings. And it is possible that your CPA will require it, right?
No, I would.
And so, and also, for folks who decide we don't want to we're a medical business, but we don't want to file for DEA registration. It may be prophylactic to have a tax opinion and a disclosure to kind of double that up in case, we're right and Treasury takes the position that if your medic's just to have a state medical license but didn't get a DEA registration, you're still Schedule 1. And then if you're adult use, I can talk a little bit about adult use in a minute, but if you're an adult use, again, there's nothing about this rescheduling order that impacts any cannabis outside that definition of medical cannabis. So adult use cannabis is still Schedule 1, and it continues to be the IRS's position that 280E applies. And so if you want to take a non-280E position as an adult use company, we strongly advise having a tax opinion and disclosure statement.
But obviously that tax opinion specific to adult use or dual use has certainly some merit, and it's reasonable for taxpayers to take that position so long as they have, like you said, disclose it and get an opinion.
Yeah, if you have a reputable attorney and accounting firm providing a reasonable basis opinion that it is reasonable for you to take the position, then yes, it's reasonable. But we strongly encourage exercising diligence and making sure you get a tax opinion to support that there is a reasonable basis.
I did want you to, and you kind of had referenced this before, but wonder if there's any more to say specifically about the Attorney General's language in the rescheduling order and his, I guess I'd say, suggestion that this be retroactive. I don't know. Did we explore that enough, or is there anything more to say?
So. I mean, I think it just keeps the door open, right? It keeps the door open for Treasury to say, look, Department of Justice suggested this. We agree that there's a basis for that. We're going to change the position and make it retroactive even further back. I mean, I think that it is there. It keeps the door open to potentially providing an opportunity for cannabis businesses to recover further back. I mean, I think too that if people want to keep that door open, one of the things they can do is file amended returns with the tax opinion. And, I think if folks want to talk more about tax opinions, Calvin, you can reach out to Calvin. He can help you figure out who to talk to there. But, that is one way too. Like right now, Treasury's position is January 1st, 2026 forward. And there are statutes of limitations around being able to open up back years. And so you may want to consider filing amended returns with the 280E position to keep those back years live in case Treasury changes its position, or you're able to kind of negotiate with Treasury some sort of settlement based in part on that language and the position.
That would be great advice to consider. One more comment. Currently there's litigation going on right now, and assumingly possibly in the future with regard to taxpayers arguing with the IRS of when 280 had gone away. So presumably that this language by the Attorney General could be helpful in that litigation as well. What would you think?
Yeah, so Top Organics is a case that's going in New Mexico right now. It's a little bit of an interesting case because it is a statutory argument, but the years predate the Department of Health and Human Services report and recommendation. So there are some tax opinions that say it is only reasonable to take the position starting in 2019 because it is in 2018 that HHS determined, HHS being the gold standard, the one who under the CSA determines and makes a recommendation for kind of which classification a substance falls within. That it really can only be 2019 forward. In the Top Organics case, it's like 16, 17, 18, no, 17, 18, 19. So it predates the HHS's determination. And so it is really kind of taking the position generally that everybody knew and understood that cannabis no longer fell within the meaning of Schedule 1 or Schedule 2. The HHS report is not the determining factor, but a reinforcing factor. And so it is, we think, factually a little bit of a harder argument and will not be dispositive for folks who are taking a position that is relying on HHS in 2019 forward. But I do think I would expect that, the attorneys in the Top Organics case may try to leverage that language. I think too, the interesting thing, I mean, we're cannabis and tax nerds. I was waiting for years, literally years, to figure out how the IRS was going to explain why Congress chose the language within the meaning instead of the defined term listed substance. And in the Top Organics case, they basically just say listed substance means the same thing as within the meaning, which is, I'm going to be a little bit of a law nerd for a minute. There are these canons of statutory construction, and when you're interpreting a statute and there's different terminology, particularly if you have a defined term, you're required to give them different meaning. And so I already think that the IRS's position there was a little bit weak. And I think that there certainly is room to leverage some of the language from the order in that case.
It would seem in theory that this within the meeting language could just to some extent be helpful for the government if there was, let's say, another drug come along that isn't listed but should be, that then they could make the argument that, well, it hadn't officially been listed yet. It was obviously because it was done so later and was dangerous all along, should have been, so it was within the meaning. So the argument could seem to go both ways.
Yes, exactly. But there is a legitimate policy rationale for why Congress would want to say that IRS has some discretion around when something falls within the meaning of. And the last thing I'll say on that is, when I think about this, I think about it in the context of, we talked a little bit about what rescheduling looks like under the normal process, right? You have a petition to reschedule, then you have Department of Health and Human Services that does an analysis and makes a recommendation. There's notice and comment, and then there's a proposed rule to reschedule. So that's happened in cannabis. Under the Biden administration, DOJ issued a proposed rule rescheduling it to Schedule 3, and then there was an administrative law judge hearing. If you think about it, necessarily, before the federal government issued a proposed rule rescheduling something, they would have had to have determined that it no longer fell within the meaning of the schedule they were pulling it off of, right? And that is based in part on the HHS report, which is a mandatory part of the rescheduling process, the normal rescheduling process, and then also, the public comment. So lots of interesting nerdy arguments around when 280E stopped applying.
Not a lawyer, but it certainly makes sense to me. Um, Last thing about 280E, and we kind of spoke to a little about with regards to the Treasury's announcement they made, but to what can we say about the application of 280E relief for taxpayers that are both adult use and medical licenses? What do we know or what do we not know at this time?
Yeah, and maybe I can talk a little bit about the adult use rescheduling process. So again, the final order did not do anything to impact the schedule of any cannabis that falls outside the definition of medical cannabis. But it did cancel the administrative law judge hearing that had kind of been sitting in purgatory. The judge had retired and it wasn't moving forward, and then set a date for a new hearing. So that's June 29th. And so basically, what the final order says with regard to kind of cannabis generally, we're going to keep moving forward with our rescheduling process. And we're going to continue on with the process that was initiated by Biden. We're going to use the public comment. We're going to use the HHS report. And the administrative law judge hearing is kind of the final step in the process. We've got the proposed rule rescheduling it to a 3. And so we expect that the administrative law judge hearing will wrap up sometime in July. And after that point, the DOJ and/or DEA, who both have authority to issue final rules around rescheduling under the Controlled Substances Act, will either issue a final order rescheduling cannabis more broadly to a Schedule 3, or could potentially, I guess, reschedule it to a 2, or won't do anything. If there is a rescheduling order in 2026, rescheduling cannabis more broadly to a Schedule 3, then medical cannabis and adult use cannabis, which is a construct of state law, neither one will be subject to 280E. And that's one of the reasons why we think that Treasury is going to wait to issue additional guidance around accounting, how to account if you're medical and adult use, because it is possible that that issue goes away. We would expect that if there is a rescheduling order in 2026 related to cannabis more broadly, and this could turn out to be wrong, but we would expect that Treasury would issue similar guidance, making it effective as of the beginning of the year. And so it is possible that in 2026, any state licensed cannabis operator is going to be able to file their taxes like any other business.
Yep.
This is so exciting. Like any other business, without a tax opinion or a disclosure statement. And so, but until then, if you're medical and you're adult use, if you want to be assured, or you want to take the most conservative approach with regard to medical, you would get your DEA registration. And if you want to take a non-280E position with regard to adult use, you would need a tax opinion and a disclosure statement.
So it kind of sounds largely, but we'll just have to sit and wait for A, to see what happens with adult use rescheduling, and then B, to the extent that doesn't happen, hopefully the IRS comes up with some fantastic guidance on how to handle this.
And one of the things, there's 2 things I wanted to say quickly, just in follow-up. So one is, we're not going to know what's going to happen with rescheduling more generally within that 60-day window for filing for the DEA registration. And so just so folks know, and I might have said this, but I want to make sure it's clear, that 60-day window starts the date that the final order was published in the Federal Register, which is April 29th. There are questions about whether or not that means June 27th, which is a Saturday, or for most federal deadlines, it's the next business day. But here it's not really a deadline, it's a filing window. And so we're encouraging people to be conservative and file before the 27th if they're going to file. But one of the things folks need to understand is you're not going to know what the federal government is going to do with regard to rescheduling generally before that 60-day window lapses.
Yep. So we started talking about the potential of adult use rescheduling and what that could or couldn't mean for 280E. I'd like to go back to that and talk a little bit more about what we do know beyond what we've already said with regard to adult use rescheduling and the hearing. And do we have any expectations or thoughts on how that's going to turn out?
If you look at the order, so there's a couple things that I think are helpful to inform what might happen. So even though in oftentimes it is the DEA that issues a final rule, DOJ has really taken the lead since the Biden administration in rescheduling. So the proposed rule, rescheduling to a 3, was issued by DOJ. This final rule for medical cannabis was issued by DOJ. And so we would expect it, or we would anticipate that a final rule, if it does issue, would be issued by DOJ. If you look at the president's executive order from December, it talks a lot about HHS's report, how everybody knows that cannabis isn't a Schedule I drug. People have known for a really long time that it has medical benefits, and directs the Department of Justice, at that time it was Attorney General Pam Bondi, to complete the rescheduling process as quickly as possible, basically. If you look at the final order for rescheduling medical cannabis, even though it's rescheduled under the process under the treaty convention, so it doesn't matter what HHS says, it doesn't matter what the public comment said. Acting Attorney General Todd Blanche took several pages to go through the HHS report and essentially bolster it. Here's what HHS found. HHS found that cannabis generally, no distinction between medical or adult use, does not meet the criteria for Schedule I or Schedule II and should be Schedule III. So if it is Acting Attorney General Todd Blanche who is issuing the final order, especially because the president had an executive order, essentially directing them to reschedule, the expectation is, unless something goes really sideways, that there probably is going to be a final order rescheduling adult use cannabis. Something could go really sideways. This is a very unpredictable time in US politics. But that is the expectation, that Todd Blanche wouldn't have used that language, wouldn't have gone through the HHS report unless that was something that he was going to use for rescheduling for cannabis more broadly, because it didn't matter for this medical rescheduling process.
Yeah, so hopefully that sounds like a good omen, and that turns out that way.
The other question, though, Kevin, just really quickly, is even if they reschedule, there is a question as to whether or not there will be a path to federal legalization, like there is for medical cannabis.
Oh, it's a good question, yeah.
And so there are a couple of different scenarios that could play out. So one is that there's no rescheduling, and so you have medical cannabis that's federally legal and not subject to 280E, and adult use cannabis that is, Schedule I and still subject to 280E, and then Treasury issues guidance about how you do accounting. And another potential scenario is that you get rescheduling for cannabis generally, but no path to federal legalization for adult use cannabis. So under that scenario, beginning of 2027, you would have state licensed medical companies, 280E doesn't apply, and they enjoy the benefits of being federally legal. Adult use companies, 280E doesn't apply, but they still are just state legal, operating perhaps under a continued kind of position of non-enforcement, don't enjoy the benefits of federal legalization, but 280E doesn't apply. Another scenario is that the final order creates some pathway to federal legalization for adult use, whether that's DEA registration, whether or not that's some other kind of federal registration, and in which case you would have all cannabis, medical and adult use, enjoying the benefits of being federally legal, and also 280E not applying. So there's a couple of different scenarios that could play out. Lots of kind of unknowns on where we're going to land.
What would be your expectation about how much of what we'll learn about the direction we'll go during that initial hearing at the end of June? Do you think we'll get a pretty good idea?
So I think we'll get a sense from the administrative law judge hearing around rescheduling if there's a recommendation from the administrative law judge that it be rescheduled to a 3, then you're going to have HHS recommending that it be rescheduled, the president directing that it be rescheduled, 70% of the, I believe it's around 70%, don't quote me there, but of the public comment supporting rescheduling, and then administrative law judge. Like that will where we'll get information about kind of whether or not there's a path to federal legality is going to be in the final order. So any final order would, if there is going to be some additional regulation or licensure or registration by the federal government, would similar, we think, to this final order that was issued on April 23rd, essentially create rules around that. And so that's when we would know what the expectation is.
That makes sense. I forgot, I did want to ask one question going back to registering with the DEA, and we had talked quite a bit about advantages, disadvantages, things to consider. I forgot to ask, and I feel like this is an important question. What your thoughts are with regard to timing and maybe things that people should be doing, whether they're going to register or not, or what they should be doing and considering in the near term up to the 60 days and maybe after the 60 days.
Yeah, so I think it's important to understand that if you miss that 60-day deadline, it's not that you can't file for the DEA registration. It is that it is possible that the DEA who in this order said, hey, look, if you file within 60 days, we're going to let you continue to operate under just your state license. If you file outside the 60 days, we don't know that this is going to happen, but it is possible that DEA says, hey, look, you had the ability to continue to operate without your DEA license. You failed to file in the timeline. You need to cease operations until you get your DEA registration. Additionally, you won't have the benefit of the expedited review and approval process, and presumably would get to the back of the queue. It is going to be, we think it's going to be really difficult for the federal government to process all these applications in 6 months. But they will be prioritizing those that were filed within that 60-day window. And so that could delay you getting your DEA registration. The other complication is that we are starting to see some states come out and say, I think Oklahoma is one of them, Virginia, say, look, the federal government says this is mandatory. If you do not apply for and get a DEA registration, we're going to enforce against you as in violation of the law, and or you're going to need a DEA registration in order to renew your license going forward. We're seeing a lot of state regulators still trying to figure out what their position is going to be. And so there is some risk that you let that 60-day window lapse, don't file for the DEA registration. Your state regulator comes out and says, we've done our research. We think this is mandatory. We're going to require that you either provide proof that you filed or a DEA registration in order to renew your license. At which point, you may be in a position where it impacts your license renewal at the state level. And so those are other kind of risks. And the last thing I'll say is, I think I mentioned this. We don't think that there's a legal benefit to filing sooner rather than later. And so one of the things that we recommend, and if folks are interested, we're happy to have calls with anybody on this that might be interested. And we've put together templates and checklists and things to help people organize the information. But what we're recommending to folks is get your information together because some of it is a heavy lift, and wait. Pick your drop dead date when you're going to file, and that might depend on how big your business is. If you have 300 locations and 3,500 employees, you probably don't want to file 4 days before the deadline. But if you're a smaller operator, 2 registrations, 25, 50 employees, like that might impact your timeline. But have everything ready to file. And then, so that you're ready, and then hopefully we have additional information. And that's particularly important for folks who are co-located or doing medical or adult use. If you're standalone medical and you're just retail, you've got your retail application for medical dispensaries. You don't have these outstanding questions about what happens if you're co-located, what position is DEA going to take? Are they going to require certain separation beyond what state law requires? And so you're kind of in the safest position to be filing sooner rather than later. Although again, there's no rush as long as you file comfortably within the 60-day window.
So be prepared to file and keep the 60-day window in mind and keep pay attention to any additional information that may came along.
The other thing I'll say quickly, because we just are learning this now, is that they are asking for like once you've filed, they're asking sometimes for supplemental information. So for example, um, you're supposed to upload a copy of your state license, but you can't do it. It just simply doesn't allow you to. And so we're getting emails back after saying you need to provide a copy of your state license within 5 days. If you don't provide it within that 5-day window, we're going to invalidate your application and you're going to lose your application fee. And so just being prepared for requests for supplemental applications, like people know this from your state license, you need to be monitoring whoever the contact person is, making sure that you're not missing communications from DEA around supplemental or questions about your application, because they are asking for supplemental information at this point.
We do have several questions in, I guess, 5 minutes. Do you care if we try to go through some and get through as many of these questions as we can?
Yeah, I'll do my best.
What can you share about cultivation and manufacturing applications where they are located and if they're available?
So they're not available yet. The DEA has indicated that they're forthcoming. They have also said that you can use the existing bulk manufacturing license to file registration application to file. And so what we're telling people, unless you have a business reason to file sooner rather than later, is pick your drop dead date. If they haven't published the specific applications for cultivation and manufacturing, medical cannabis cultivation manufacturing at that point, use the existing bulk manufacturing application to apply and expect that there will be supplemental requests for information.
Okay. I'm a licensed grower in Oklahoma and have a recent background check from OSBI dated May 6, 2026. And then there's no actual questionnaire. I assume I don't know what the question could be.
So I wonder, I mean, perhaps the question is that sufficient to rely on? And so again, this is where it's important to connect with legal counsel. It is possible that that is sufficient for answering the question about state criminal convictions. It may not be enough to answer the question about criminal convictions, federal criminal convictions related to a controlled substance, and it probably doesn't cover disciplinary actions. There's a couple of different things we're recommending to our clients who are making business decisions. We have developed affidavits for the employees to complete themselves that then the licensed company that's applying can rely on when they complete the application, that captures more broadly. But I think and when we talk to the DEA, I mean, under normal circumstances, for a DEA registrant, individuals that have access to the controlled substance cannot have a federal conviction for controlled substances. You can get a waiver for that. It doesn't necessarily apply to an owner. It's really, it's about people who have access. We don't know if they're going to apply that restriction to state medical cannabis businesses. As folks know, there are some states that require you to have a conviction in order for you to get certain priority. But it is really important that you be thoughtful when you get background checks back, or if you have employees disclose certain convictions, that you think about them, because there is an opportunity to provide an explanation. You want to be really thoughtful about what that explanation is.
Makes sense. In the dispenser application, section 4, bullet 5, asks anyone who had been involved in ownership or operation of the firm previously manufactured, distributed, and/or dispensed any controlled substance without DEA registration authorizing such activity. What are your thoughts about this question? I think maybe we kind of already addressed that.
Everyone except for a small subset of people are going to check yes. I was talking to a DEA field investigator the other day, and she's like, "Oh yeah, we're expecting everyone to check yes. Like that's going to be a yes." And so if it is the case that you've operated under a state medical license, then the answer to that, and you didn't have a DEA registration, which you probably didn't, you weren't entitled to have, you wouldn't have qualified for, you're going to check yes, but then there's the place to put the explanation, right? And you just want to be thoughtful about that explanation.
We have another question about medical and adult use license and 280 application. I think we answered that pretty well. I would say generally, to the extent that there is broad rescheduling, that's a moot point. To the extent there isn't, hopefully the IRS will provide some guidance that can be helpful. So, is this talk being recorded? I believe that it is, and we'll look into if it's just going to be shared automatically, or if you can connect with us and then we can share it. In California, we already have been to the rodeo of med is different than AU cultivation tax. In 2019 time frame, it failed. The state could not keep track of it. I guess that's just a comment, which I don't kind of seems to make sense to me, but we'll see. The plant is grown at the retail shop. In one situation, it is the weed is old as med. In the other situation is adult use. The position we are in is terrible and half-baked. I don't necessarily know that I can argue with that
But
comment.
I think, Calvin, one thing you and I were talking about at the beginning here is I think that this is really frustrating for folks, but almost everyone on this call has been through this before, right? Almost everyone started their operation in a state that had just legalized. You were working through it while the state was trying to, again, state was building the plane while they were flying it, federal government's building the plane while they filed it, and you did it. You made it through. There are some growing pains, but one thing that I will say about this is a path to federal legalization. If you had told me 8 months ago that we were going to get federal legalization in 2026, I would have laughed at you probably. So it is like, in some ways, I'm viewing it as a necessary evil. This is the process to normalization, right? Like it is the case that if you get a registration for a pharmacy, you're letting DEA know who your employees are and what criminal convictions they have. They're treating you, before April 23rd, they were treating you as a felon.
Yep.
Today, they're treating you like a pharmacy. There's something pretty amazing about that. And I understand people, it's stressful and it's hard. And we're happy if there are folks who want to reach out and want some help and want some additional guidance, please do. I think my information is going to be included in something. But I do just want to kind of acknowledge that these are growing pains that you've probably been through before on your path to building your business. It's just one more step towards legalization and normalization.
Yeah, definitely. And yeah, with regard to sharing our contact information, I don't know that we have that right now, but we can certainly find a way to share that with um, all the registrants. There's a couple questions around the registration and what that means for interstate commerce, shipping between other states, which I think is a good question.
I can answer that if you want. If folks want to stay, I know we're over time, but I can answer that. So for medical cannabis, I mean, the final order is very clear that it is deferring to state law, and almost every state, because they were working to comply with the Cole
Yep.
Memorandum, or at least the concepts in the Cole Memorandum, prohibited interstate commerce. So theoretically, if you have multiple states, California and Oregon, who both changed their laws to allow for Oregon manufacturers to sell to California license holders and vice versa, it's no longer federally illegal, so it can go over state lines. There's no prohibition, and you will be in compliance with both state laws. We do think, however, that for federal legalization and even for export to other countries, that is going to require changes to state law
Yep.
before it goes into effect. But this is a pathway, a potential pathway to interstate commerce.
We've gotten through most of the questions, and as you mentioned, Hannah, we're over time. But I guess I want to thank everyone who offered questions and participated in this webinar, and most importantly, Hannah, I'm really grateful for you to take your time to have this discussion. I thought it was very helpful and a lot of great information. So thank you very much.
Yeah, it's my pleasure, Kelvin. Thank you, and thanks to everyone who participated.
Have a great day, everyone.